we've got a truncated panel instead of 16 or so people. We've got 4 people. At the end of the voir dire, each lawyer can have 1 strike. But other than that, it's going to be like an ordinary voir dire. Each lawyer will have a half an hour in which the voir dire, the jury panel, he will be the judge. It's all being videotaped. If you want to review it again later, you certainly can do so. We have a library of these voir dires going back several years. And after the voir dire is over, we're going to ask each of the lawyers to talk to you about their voir dire philosophy and to answer any questions you may have. Okay? Okay. If you can't hear, indicate that you can't hear the judge. You ready to go with the video?
It's live. We're live.
What?
We're live. We're ready.
Okay. You?
Okay. Our prosecutor tonight is A.Bennett from the County Attorney's Office. I imagine by now most of you have met him. Alan graduated from Baylor and says that from the time he's in law school he intended to go into criminal defense work. Came down and clerked for Lowell Clayton, a local defense attorney, just for a very short period of time, and then was able to get a job in the county attorney's office. How long he lasts, I think, will depend on when the money calls for him. The defense attorney is Mark McCrimmon, who was a clinic student. Saw him how many years ago, Mark?
A few. 10, 12. 6, 7.
6, 7 years ago, and went to work for the county attorney's office and prosecuted over there until about, what, 1 year ago?
Well, no, 2 years at the county, then 2 years at the district.
That's right, you were in the DA's office. And he's now out in private practice. Okay, I'll call the case. Cause number 403-674, State against Victor Alvarez. Mr. Bennett, you may proceed.
Thank you, Your Honor. Please the court, counsel. Ladies and gentlemen, my name is A.Bennett. I'm the assistant county attorney here in Travis County, Texas. I work for Mr. Ken Oden, who's our elected county official. And this part of the trial is called the voir dire. Now, voir dire is just a French term, and to be perfectly honest, I don't think I was quite awake today. Someone translated that for me because I never got it in law school. I've been told since then voir dire quite simply means to speak the truth. More importantly, though, is the purpose of voir dire. And this is the part of the trial where myself and counsel for the defendant have the opportunity to talk with you, the body of you, of which a certain number will be chosen as the jury in this case. This is the only time I'll have a chance to talk with you. I'll be talking in front of you at various times in this trial, and at the end of the trial I'll be talking again to you, but I will not have the opportunity to talk with you again. I'll not be able to speak directly with you. You will not be able to speak directly with me. In fact, after this case begins, there are certain rules of evidence and procedure which prevent me from engaging in conversation with you. So if I see you in the hallway or I see you getting onto an elevator, I'll most likely take the stairs. And it's not, I'm trying to be rude, I'm not interested in how your day's been. It's just that there are certain rules of evidence and procedure that prevent me from having that type of interaction. I suspect the judge will so instruct you once the voir dire is completed, once this case has begun. The purpose of voir dire, quite simply, is for me to find out certain thoughts or feelings or concerns you all may have as jurors about the particular case at hand. I can do this best probably by way of an illustration. I've got a good friend of mine, a friend I grew up with all my life. He's now married and has 3 children, the oldest of which is 9. The middle one is 6, and he has a young daughter now, about 18 months. And being his friend all these years, I've certainly had the opportunity to babysit for those children a great number of times. There have been times when I've been at his house and suddenly Luke comes running into the room saying, "Dad, Dad, Jerry hit me." And sure enough, Jerry's following right behind him saying, "No, no, Dad, Luke started it. Luke hit me first." And just by my experience of having watched those kids growing up and having watched them been raised, before I hear anything else, I already have an idea as to what really happened. And the reason I'm telling you this is to let you know that there's nothing wrong with that. That's perfectly natural and that's perfectly normal. Those are certain defense mechanisms that nature provides us with to help us cope in everyday life. The problem here is that we're now in a court of law. And in a court of law, we simply do not have room for prejudices or biases, whether they be in favor of the state or against the state, or in favor of the defendant or against the defendant. And this is the part of the trial where we try to get a feel for those kind of things. For example, my mother's not sitting here amongst the panel, but obviously if she were, opposing counsel certainly wouldn't want her sitting on the jury, and I'm sure my mother could say with all conviction, I could be fair and I could be impartial, and no, I wouldn't pay any more attention to my son than I would as opposing counsel. But obviously, whether or not my mother's sitting here and whether or not she may be on the panel is something Mr. McCrimmon would want to know. And that would be a good place to start. Is there anyone here who knows me, who has ever dealt with me, or has ever met me? I don't recognize any of you. Is there anyone here who knows Mr. McCrimmon, counsel for the defendant in this case? Or knows his client, Mr. Victor Alvarez? Is there anyone here who knows Ken Oden, our elected county official, the elected county attorney of Travis County, who's ever had any dealings with our office? Okay, I'd like to talk to you briefly about certain principles of law, and believe it or not, as a jury, you do not have to have any knowledge of the law itself. All you need to be is patient, understanding, and to not decide anything until you've heard all the facts of this case. There are a few principles that I would like to talk to you. Has anyone ever heard the term preponderance of the evidence, or beyond a preponderance of the evidence? Ms. Ford, have you ever heard that term before?
No, sir.
Not on TV or anything? Is there anyone on the panel who's ever heard that term, has ever heard it used? Mr. Bird, is it?
Yes.
I noticed you're nodding your head. Have you heard that term used before?
I think I've heard it on LA Law.
On LA law? That is a term used to describe the burden of proof in a civil case, in a civil lawsuit, and during the voir dire, attorneys will always pretend like they're the scales and talk about the preponderance of the evidence being 51% versus 49. Just tipping the scales slightly meets that burden of proof, and means the side who tips the scales wins. In a criminal case, the burden of proof is beyond a reasonable doubt, not beyond a shadow of a doubt. Ms. Ford, I noticed you're nodding your head there. Have you heard that term before?
Yes, I've heard about it.
What does that mean to you, beyond a reasonable doubt? And just again, just in your own words.
I know it's taken, you use it when you're deciding whether the accused is guilty or not, and if you have a doubt in your mind that maybe he's not guilty, then you can't find him to be guilty.
Certainly, that is probably a fairly good definition. The key thing here is that beyond a reasonable doubt is something that the Texas legislature nor the Texas Court of Criminal Appeals have ever defined for us. It's something that each of you, if you serve on the jury, have to decide for yourself, and it's something you decide by using your own common sense. Now, it's not beyond all doubt. It's not beyond a shadow of a doubt. It's not that those butterflies you may have in your stomach. It's a doubt that you should be able to articulate to your fellow jurors during your deliberations, a doubt that you could explain to them in reasonable terms. Does anyone have a problem with that? Do you think that maybe the state should have a higher burden of proof? Do you think the state should have to prove beyond all doubt the defendant's guilt in a criminal case? Mr. Burleson?
No, I think that's fair to the accused. It's not just the 51% that you spoke of, but
Somewhere
a little bit more than that, it seems like, yeah.
Mr. Daly, you and I haven't had a chance to speak. How do you feel about that?
Sounds reasonable to me. I don't think you could ever prove anything beyond any doubt.
Certainly, and that's probably why we have that standard, beyond a reasonable doubt, but not beyond all doubt. And here again, like I said, this is the last chance we will have to talk. If there are any questions, comments, thoughts, or feelings you have, feel free to just raise your hand or somehow indicate to me that there's something you want to know about. We can stop, talk about it. I'll try to explain as best I can. If I can, we may have to have the judge explain it or go before the judge. The case at hand, in this case, is a driving while intoxicated case. I'm sure some of you, when you were subpoenaed, would think you were going to sit in an elaborate courtroom and hear a capital murder case, but although this is a driving while intoxicated case, that does not lessen the importance of it. Mr. Burleson, do you have any thoughts or feelings about the driving while intoxicated laws? Do you think they've gotten tougher or more lenient over the years?
Well, I guess I've seen ads on television and stuff, and I've gotten the general impression that they've gotten tougher with the driving while intoxicated laws, but I don't know what the standard is. I don't know how you get pulled over or anything like that.
Just seen those Mothers Against Drunk Driving commercials, that kind of thing?
Yes, sir, I've seen that.
Is there anyone here that's a member of Mothers Against Drunk Driving or Students Against Drunk Driving, any one of those organizations? Anyone contribute to any one of those organizations?
We do.
You do, Ms.
Yes.
Ford? Is that you and your husband?
Yes, sir.
Are you fairly active in it, or just something?
Yes, sir. I just have some friends that are active in it. I don't really have time for that type of activity.
Oh, I see. The elements of the driving while, yes, sir. Mr.
I'm not a member of any of those organizations, but I don't drink, and I think the sin drink.
And that was certainly something I was going to get to in a little bit. There are a lot of reasons why people do not drink. There are medical reasons, there are religious reasons, and there are simply very straightforward reasons people do not like the taste of alcohol. And I've taken from your response there that you feel very strongly about drinking based upon religious reasons.
I have religious convictions about it, yes.
Certainly, and that is a very prominent and very well-respected reason. Is there anyone else here on the panel that does not drink for any of those reasons?
I don't drink, but it's really more of a matter of taste. While I'm a Baptist, I don't sign up for all the man-made doctrine in that religion, but I just don't like the taste of it.
Certainly, and that's reason enough to, and like I say, there are a lot of reasons not to drink. And by the same token, when I get home, sometimes I realize there are a lot of good reasons to drink. I take it then, Ms. Ford and Mr. Byrd, that perhaps you two do have a drink from time to time?
Every chance I get.
When was the last chance you had?
Well, I don't want to say that I'm an alcoholic or anything, just within reason. Like during lunch or something, I'll have a drink. And maybe when I get home, I'll have a drink or two.
Oh, certainly. That's on a fairly regular basis. Well, tell me, Mr. Byrd, well, basically, let me talk briefly again about the elements of DWI, the case at hand. Basically, all the state has to prove in a driving while intoxicated case is that on or about, in this case, January 10th, 1988, here in Travis County, Texas, the defendant, Mr. Victor Alvarez, did then and there operate a motor vehicle knowingly and intentionally on a street or highway here in Texas, Travis County, while intoxicated. And that is quite literally all the state has to prove in its case to convict Mr. Alvarez. Is there anyone who feels the state should have to prove more?
Well, I think they should definitely prove that he was driving while intoxicated.
Oh, certainly.
I was arrested once for a DWI, and I took a breathalyzer, and I was released because I wasn't driving while intoxicated.
And certainly, and I'm sure you'll hear testimony by the officers and by an intoxicator operator of the reasons why officers give field sobriety tests and why they do provide an intoxicator test to give a suspected person every benefit of the doubt to prove that they are not intoxicated.
That officer was ready to hang me up. He thought I was drunk. He said, "I'm going to jail."
Certainly, and there are a lot of times where there are officers out there who make judgment calls in the dark of the night under facts and circumstances that most people don't come into everyday contact with, and they do make those kind of judgment calls, and quite literally, police officers, like everyone else, are human, and they do make mistakes, and quite fortunately, and quite reasonably, they made a mistake in your case. And
He said he's never seen anybody more drunk than I was. And I was on, and they had to let me go.
Oh, certainly, and that is a matter of policy. Some police agencies, if a person is brought down and blown in a toxic blows below a certain level, they simply decide that, well, perhaps this person's wrong, perhaps the officer did make an error in their judgment, and that person is released. And I think we're all quite aware.
I really don't think their machine is worth it. I don't think that can really take a machine. It's hard for a machine to pick everything for everybody.
Oh, certainly.
I just think there's a lot of fallacy in those machines.
Certainly, and that is a very valid point. I'm sure that's something you'll hear a good deal of evidence on in this case. An intoxilizer, and I know you have certain feelings on it. Is there anyone else who knows anything about the intoxilizer machine, how it works, how it operates? Basically, it's a machine utilized by the Department of Public Safety, by the Travis County Sheriff's Office, and by the Austin Public Police Department, which takes a sample of breath. Someone blows into it with a certain degree of strength for a certain amount of time. It captures that sample, and then through a certain process I expect you to hear expert testimony on, can analyze it to determine the alcoholic content of that person's breath. And I take it, Mr. Byrd, you don't have a great deal of faith in that particular machine.
Well, unless they've improved that machine in the last 6-7 years, have they changed them? There are new technology. I could believe if the technology is better.
Certainly, there was a time where what was commonly used is called a breathalyzer. It was just a matter of chemicals that were mixed up that would, as I understand it, have a certain change in their coloration, which would indicate certain levels of intoxication. An intoxilizer simply gives a numerical printout.
At this time, I'd like to object, and if we could approach the bench, please.
Yes, you may.
Just say that. I would object in that the state now is going into matters that would be better addressed by the expert. I know that he's caught talking to the juror here, but if he could just talk in more general terms and not talking about what a breathalyzer is versus what an intoxilizer is, those are things that should come out through expert testimony.
I think it should be kept in general terms, and I sustain the objection to that extent.
Certainly, Your Honor. I suspect, Mr. Byrd, all members of the panel, you will hear expert testimony as to the intoxilizer, how it works, how it operates, and I suspect you will hear evidence from the defense side as to how it works and how it operates. Are you familiar with, is anyone here familiar with a polygraph machine, commonly called a lie detector? I know there's several of you nodding your heads. A polygraph is a machine which, well, what do you know about that, Mr. Carlson? You've heard of it, yes?
You know, I've seen it on television. You see wires hooked up to people's fingers and whatnot, and they
Certainly.
measure the reaction, the bodily reaction to different questions.
And it's primarily designed to indicate when someone is telling a falsehood. The unique thing about a polygraph is that the results of a polygraph test are not admissible in any state in the Union. If myself and opposing counsel sit down and agree in writing before trial ever starts that the results of a polygraph would be admissible, and even if we approach the judge and say, Your Honor, we agree to let these results come into evidence and be put before the jury, those test results do not come into evidence. And the reason being, because although there's a large body of scientists and doctors who say, yeah, that's a valuable machine, it is reliable, it does accurately reflect when someone is telling falsehood. By the same token, there's a whole other large body of scientists and doctors who say, no, it's not reliable. And the truth of the matter is, the polygraph is not accepted in the scientific community, as of this time, as being reliable and accurate and valid. And for that reason, the results of a polygraph are not admissible into evidence. And getting back briefly to what you talked about, Mr. Byrd, the intoxilizer, on the other hand, is recognized by the by the scientific community, by and large, as being reliable and accurate and valid. That's why we're allowed to bring to you the results of an intoxilizer. With regard to the specific performance of the machine and how it works and how it operates, you will hear expert testimony on that, I suspect, in this trial. Was there anyone who felt that the state would have to prove anything more than the elements I mentioned of driving while intoxicated? For example, would you want us to prove where the defendant was or how much he'd been drinking, things of that nature? Yes, sir.
Does when you prove that, does it measure tolerance, the person's tolerance for alcohol at all? I guess I'm a student and I've got some friends that seem like they drink a lot, but it doesn't seem like it affects them very much.
Well, it seems your question is basically getting toward the definition of intoxication. I suspect in the charge the judge will give you at the end of this trial, the definition of intoxication will be someone who is intoxicated when they have lost the normal use of their mental faculties by reason of introduction of alcohol into their system, or someone who is intoxicated if they have lost the normal use of their physical faculties by reason of introduction of alcohol into their system, or someone who is intoxicated if they have a breath alcohol content of 0.10 or above. And there again, Mr. Byrd is getting back to the intoxilizer you and I have talked about briefly. That's the legal definition of intoxication given to us by the Texas legislature. And the reason I stress the word "or" in there is because you as jurors would be able to find the defendant guilty if you found him intoxicated on any one of those standards. For example, two of you may say, well, I don't believe the results of that intoxilizer. Based upon the testimony and the evidence I heard, I certainly don't believe he had the normal use of his mental faculties. And two of you may say, well, I don't believe the intoxilizer, and I think he did have the normal use of his physical faculties, but I don't think he had the normal use of his mental faculties. You can convict on any one of those standards, and you all don't even have to agree on which standard. Is that perfectly clear? Does anyone have a problem with that, or have any concerns about the law as it's written in that way? Mr. Carlson, unless you're shaking your head, do you...
I have no problems with that as long as it can be any one of the three, I suppose.
Certainly. For example, you may think, well, I don't believe the intoxilizer based on what I've heard, and I think physically he was doing fine, but mentally I don't think he had the normal use of his mental faculties. Do you realize that you could find the defendant guilty based on that one single element or that one single definition?
Yes, sir, that's what I understand now.
There isn't one who feels
So we could theoretically feel that he had he had full control of his mental and physical capabilities, but if he had a 0.1 or whatever you described it as over that, then even though we think he's not drunk, if we find that we agreed with the intoxilizer's results, then even though we don't think he's drunk, you're going to find that he's guilty.
Well, I'm not...
I mean, then statutorily or according to the law, then he's Right.
Certainly, and there is a good argument, and which has been raised many times, that, well, if you're defining someone as being intoxicated once they have a breath alcohol content of 0.10, then they're already guilty. I mean, you're just presuming them to be guilty already, and the Texas Court of Criminal Appeals has said, no, that's not a presumption of guilt, that's merely a definition of intoxication. The reason, as I was talking with Mr. Byrd about the intoxilizer, that you would hear expert testimony from a state's witness as to how the intoxilizer works, and it would be your role as jurors to determine whether or not it is a valid and accurate machine, whether or not it was functioning properly that night, whether or not that test was administered accurately. So, for example, in a case where a defendant does blow above a 0.10, certainly you could all say, well, we don't believe the results of that intoxilizer machine based upon the testimonies we heard it, based upon how that test was administered, that kind of thing. Does that answer your question? Do any of you agree?
Your Honor, I'm going to object because I don't think that does answer the question. Mr. Daly had a question about whether or not they believed as a jury if the defendant was not intoxicated, but the result of the blood alcohol content as evidenced in the breath test was over 1.0, would they still have to be going with a guilty verdict? I think the answer to that is no, because if they do not believe that my client, Victor, is intoxicated, the only thing they have to do under the law is to say not guilty. I wish that would be stressed to the jury as a whole.
Overruled.
Thank you, Your Honor. I believe what I was trying to express, Mr. Daly, is that you can find the defendant guilty on any one of those standards, even if you believe that physically and mentally he was in full and complete control of his mental faculties and of his physical faculties, but you believe that he was intoxicated by virtue of the fact that his registering a certain level on an intoxilizer. If you believe that test was administered properly and accurately, if you believe in the validity and reliability of that machine, you could find him guilty based upon that standard. I hope that answers your question a bit more. There are a couple of questions I need to ask the panel as a whole, and I realize some of them are somewhat personal, and I certainly do respect your rights not to answer those questions, but at the same time I certainly do need to get a feel for them. Is there anyone here that doesn't drink? I know Mr. Burleson, Mr. Daly, you do not. Mr. Byrd, you said you do drink?
Yes.
From time to time? What do you drink, generally?
Depends on the mood.
Okay, but you're not limited to just...
A little bit of beer every once in a while, some wine in the evening, at dinner time, and then maybe some scotch or something later.
That's all in one day?
Oh, just various days.
Oh, okay. Do you ever drink enough to where you begin to feel the effects of that alcohol? How do you first begin to notice those effects?
Probably get sleepy.
A little bit tired. Ms. Ford, have you ever seen anyone that you knew to be intoxicated?
Yes.
I'll give you one characteristic of that person, one thing that told you that person certainly was intoxicated.
Generally, the first thing I notice is the smell of alcohol in their breath.
Smell of alcohol in their breath. Mr. Burleson, have you ever seen anyone you knew to be intoxicated?
I guess I have a tough time is when do they cross that line where you say they're intoxicated. I've never met anyone that couldn't carry on a conversation and relate to me and didn't seem like they knew what was going on. I've never met anybody like that.
Okay, have you ever seen anyone, as they say, stumbling, falling down drunk?
I guess I've seen people that were drinking that didn't have control of their balance very well.
Okay, sort of unsteady on their feet. Mr. Daly, have you ever seen anyone you knew to be intoxicated?
No, I think people who drink are disgusting. I try to stay away from them as much as I can.
Well, certainly I understand you do have strong feelings about drinking, and certainly everyone respects those feelings. But have you ever, just by chance, for example, have you ever seen a car driving down the road sort of weaving in and out of their lane?
No, sir. No, never have.
Is there anyone here that's ever seen a car sort of weaving in and out of their lane a little bit in the sport? I noticed you're nodding your head. Have you seen that?
Yes, I've seen that on quite a few occasions.
Quite a few? How did that make you feel? What did you think when you saw
I
that?
stay away from that car.
Okay, just try to give it some space to back off.
That's right.
Is there anyone here who's ever had any run-ins with the University of Texas Police Department? Is there anyone here that knows Officer Jones or Officer Cannon of the UT Police Department? Officer Robertson? Is there anyone here who knows Rudy Baker, a toxicologist? Or Malcolm Mills? Okay, and there again, those are just people that the state expects to put on in front of you as part of the evidence. And certainly we want to know whether or not you know any of them, or whether or not you've ever had any relations or dealings with them. Does anyone feel that the state needs to have an accident or an injury before we should be bringing a case of driving while intoxicated to you to prosecute that case? Ms. Ford and Mr. Byrd, I notice, I guess by the lack of response that you do drink on occasions, Ms. Ford, do you drink on occasion?
Occasionally.
And what do you drink? If you don't mind my asking.
Generally wine, maybe a mixed drink or two.
Is that with dinner or something along those
Social
lines?
occasions.
Social. Ms. Ford and Mr. Byrd, or I guess the entire panel at large, is there anyone here other than myself who has gotten behind the wheel of a car and driven down the road under the influence of alcohol and gone undetected? And the reason I'm saying that is because there have been times in my past, and I'm not particularly proud of them, but it's a matter of growing up, I guess. And there have been times when I myself have gotten into a car and proceeded down the road when I should not have. And quite simply, I need to know if there's anyone here who has ever driven while intoxicated and yet gone undetected without an accident, without being pulled over, anything along those lines. And
I have a
Byrd.
question.
Yes, sir.
While intoxicated, you mean like legally drunk, or just had a couple of beers and then drove?
Well, certainly, and that's a very good point. And as I'm sure Councilman Vince will probably point out, there's no law against having a few drinks and driving. The law is against drinking to the point of becoming intoxicated and operating a motor vehicle in a public place. Intoxicated, as I'm talking, would be getting in the car and driving down the road when you realize you probably shouldn't, or wouldn't be the safest thing. Have you ever had that, Ms. Ford?
Yes.
5 minutes, Mr. Bennett. 5 minutes.
Thank you, Your Honor. And I certainly appreciate your candor on that, Ms. Ford, and that is something that I need to know.
I want to know how much liquor it takes to get you to the level that you're drunk under the legislation.
That, again, is a very good question. And as I was talking earlier, the definition of intoxication, one of those definitions, and the only level the legislature has given us is that .10.
Is that one beer, 2 beers, a glass of wine?
That is something that, again, would probably be best explained from an expert, from a toxicologist, from someone who deals with alcohols and deals with their induction into the human system, and would probably better be able to explain that during his testimony of the case. In essence, your role as a juror, if you were chosen, would be to determine whether or not someone was intoxicated. And quite literally, that is a judgment call that as a juror you would have to make.
I guess I just didn't understand your question, this gentleman right here, that you asked him if he'd ever got behind the wheel when he was legally drunk. I mean, if he doesn't know how many beers it takes to get him to what makes him legally drunk, how would he know if he thinks he has full grasp of his mental and physical capabilities?
Oh, certainly, I understand. I think what I was asking Mr. Byrd and the entire panel at large would be whether or not in their own opinion and in their own experience and judgments, they had driven under the influence of alcohol, whereas in their own minds they knew, well, I shouldn't be driving, but I've just got to go a short ways down the road, and I should be able to get there without any problem. That was the kind of thing I was referring to, because quite literally that is something that only a person can decide for themselves, or in this case, something that you, as members of the jury, those of you who do sit as jurors, will have to choose in the case of the defendant, in this case. There's only one question I would like to ask each and every one of you individually, as my time is about up. Mr. Burleson, if I proved to you beyond a reasonable doubt all of the elements I talked about, would and could you find the defendant in this case guilty of driving while intoxicated?
I think if you prove to me that he was not in control of his mental and physical capacity,
okay, you realize
I could find him guilty.
Okay, I noticed you said his mental and his physical. You realize I only need to prove one of those.
Either one would be fine.
Either one with that alcohol content?
I think I have a little bit more difficulty with that one.
Certainly, and that would be something you would have to wait and hear all the evidence, I would imagine.
Yes.
But you would be able to find, and you could find the defendant guilty if I proved to you beyond a reasonable doubt all those elements I spoke of.
As long as his capacity was impugned in some way.
Certainly, if you felt that he did reach that level of intoxication as I defined it. Ms. Ford, could and would you find the defendant guilty of driving while intoxicated if the state met all of its elements beyond a reasonable doubt? Mr. Bird?
Yes, sir.
And Mr. Daly? Daly. I apologize for mispronouncing your name. Sometimes they don't always come out quite as well on those little cards you filled out for us. Once again, I'd like to thank you all for being patient here, as I'm sure you will be, and if it weren't for your process, if it weren't for your involvement in this process, we would not be able to have a trial today. I hope you will hear all the evidence. We'll not decide anything in this case until you've heard that evidence. And once again, on behalf of the state, I'd like to thank you for your patience in participating in this field of law today. Thank you.
Mr. McCrimmon?
Thank you, may it please the court. Mr. Bennett. Ladies and gentlemen of the jury panel, I too would like to thank you on behalf of my client, Victor Alvarez, for your patience and attention today and the presence. My name is Mark McCrimmon, and I am right now a defense lawyer practicing in criminal law in Austin, Texas. I'm out on my own right now, working with a gentleman named Joseph Turner. Joe Turner, I don't know if anyone's heard that name in the newspaper. Is anyone familiar with his name? Okay. Mr. Bennett has asked if you knew me or the judge or himself or my client. Victor, could you have us stand up, please? Does anyone know Victor Alvarez? He is a Nicaraguan foreign exchange student here in town, studying at UT. Does anyone know Victor? Also, a friend of Victor's is going to be testifying in this case, Pablo Lauriendo. Anyone know Pablo? 3 other friends of theirs, students, will be testifying in this case. A, B, and C. Does anyone know A, B, and C? Now, I was, before being a criminal defense lawyer here for the last 6 months or so, I was also in prosecution, and I was at the DA's office for 2 years, and before that I was with the county attorney's office. I never had the chance to work with Mr. Bennett, but does anyone know anyone over at the county attorney's office besides just Mr. Bennett? Does anyone know Ken Oden all the way down to any secretaries that work over there? How about anybody at the district attorney's office? Does anyone know them? Yes, and who would you know over there?
I know one of the secretaries,
Okay, who would that be?
Valerie Smith.
Okay. Now, the fact that she's at the district attorney's office, this is a county attorney's office case, and she was a secretary, not a lawyer over there or anything like that, could that have any bearing at all on your determination of the facts in this case? Okay, thank you. What we're here for today, especially in this voir dire process, is a chance, like Mr. Bennett said, is to be able to talk back and forth about the problems that are confronted in any kind of criminal case. Now, we're not here on a capital murder, true, but this is a very important and very serious case for my client and his respect and his continued ability to stay here and study at the University of Texas and then travel freely back and forth between Nicaragua and the United States. I stress that just to show how important any DWI case is, any criminal case is important to any person. In this case, it's heightened by the fact that he is not an American citizen. And I want to tell you exactly how important it is that we had a chance to talk and maybe work through some of the problems that I think I heard when you were talking to Mr. Bennett. Let me turn briefly and initially to the job that I think I have representing my client, and that is to see that justice is done. And in this case, just as it is in Mr. Bennett's case, is that a fair trial should be had by both the state and the defendant. A full investigation of the facts put together with the law that the judge will give you to come up with an answer whether or not Victor was driving while intoxicated on the night in question. The criminal trial in Texas is broken up into 2 parts. The first part is a determination of guilt or innocence. You are fact finders initially. The second part of the trial is when you talk about appropriate punishment. Right now, in this part of voir dire, throughout the first day of testimony, what we will be looking at are facts. You, as a juror, will determine whether or not you believe that the state has proven their case beyond a reasonable doubt in that Victor was drunk. was intoxicated. Now let's turn to that. The state has the burden of proof, period. Constitutional right given to my client is that the state has to put on their evidence initially to prove to you all beyond a reasonable doubt that he was guilty. Now, using this bar here, I want to show you what I consider my definition of what beyond a reasonable doubt is. Say this is halfway, 50% of the bar. This would be a preponderance of the evidence, what Mr. Bennett talked about earlier. Anything 1% over on this side would win in a civil case, and a burden being a preponderance of the evidence. Have any of you all been on civil or criminal juries in the past? Okay. Ms. Woodward?
Oh, no, not the jury, I'm sorry.
Okay. Has anyone else been on a criminal jury? Criminal or civil jury? Anyone? Yes, sir?
I've been a party to a lawsuit before.
Okay. Were you involved in the jury process itself?
No, our company was being sued.
In a civil suit? Okay. You understand that in a civil suit, the answer on those kind of questions is like who gets the land, who gets the money, who wins the contract is certainly less significant than putting someone in jail for a possible 2-year sentence and fining them for $2,000.
There's expensive horses involved, I don't know.
Okay, but no one was going to go to jail, true?
No.
Okay. Now, in a civil suit like that, do you understand that the burden of proof on the party claiming the injury is to prove something beyond a preponderance of the evidence, 51%, the scales of justice technique. Again, if this is halfway through, if they could prove to you 51%, they would win. Now, has anyone been on a grand jury?
I have.
Okay. When was that? Where was that?
It was in Austin about 1.5 years ago.
Okay. You understand there, the burdens that we're talking about here, beyond a reasonable doubt, and preponderance of evidence are not in play at all. And I want to confuse you with the jury, grand jury versus what we're talking about here. Okay. Now, moving down the scale of the burden of proof, somewhere in here, in some administrative hearings on whether or not people are mentally committed for the rest of their lives, things like that, some fairly significant and important decisions would be a standard that falls in here called clear and convincing evidence. More than preponderance of the evidence, but still less than a showing of proof beyond a reasonable doubt. Now, if we're up to here on clear and convincing evidence, again, it's not quantitative like 75% or 80%. And then you see that we're all the way to the end, near the end of the bar before we get to beyond a reasonable doubt. Okay. One more thing about that. Mr. Bennett had a notion that you need to be able to articulate the reason why you feel the state has not proven their case beyond a reasonable doubt. Now, I think that's a fine definition, and again, you can't turn to any page in any law book and get a definition of this important burden, but I would like to argue with that in that maybe not everyone is articulate as lawyers or as some of us would like to be. And I think it's important to realize that if you have one of those gut reactions, those uneasy, queasy feelings about the case, and in your own opinion, it rises to the level of failing to prove to you beyond a reasonable doubt, that I would contend that's enough. Is there any problem with that?
I have no problem with that.
Ms. Ford, do you understand that? I don't think that my own definition would have to be a fill-in-the-blank type of reason why you wouldn't prove beyond a reasonable doubt. That if you have a gut reaction that you yourself feel you're uncomfortable with the case, do you think that could be a failure on the state's part to prove to you beyond a reasonable doubt?
Well, it could be.
Okay. Do you think that you would have to be able to come up with a reason to tell your other jurors articulable, specific words?
I think that I myself would have to, yes.
Okay. Do you think that you are an articulate person?
I tend to like to think so.
Okay. Do you think that a person could not be able to express their feelings in words and still have a valid problem, which to them is a failure of the state to prove their case beyond a reasonable doubt? Is that still valid to you? If all they could really articulate is that I don't think they've proven their case beyond a reasonable doubt, I just don't feel right about this, for instance, intoxilizer, I don't feel right about this 1-0, would you give that credence and validity?
It loses some validity.
To you it does. What about you, Mr. Byrd, and Mr. Daly, you think that you could respect and give validity to someone who was not able to fill in a blank and tell you exactly A, B, C, or D, why he does not feel or she does not feel like they've proven that case beyond a reasonable doubt? Do you think if they were able to at least come up with the reason, for instance, the intoxicant and say, I just don't feel right about the intoxicant, do you think that you could then give them their belief?
So long as it's above that point over there, this one. I don't want to touch you, excuse me. This one.
You're saying if they could prove to you that the state has not proven their case beyond a reasonable doubt,
Right.
that you would be able to respect that decision on their part. Mr. Bailey?
I think I could.
Now, combined with the burden of proof is the fact that we, hand in glove here, same side of the point, is that the defense has no burden of proof. We have no legal duty to come forward with any evidence at all to prove to you that he was not intoxicated. Let me work through that with you. If Mr. Bennett works through his direct examination, puts on all of his evidence, and comes to the point where he closes his evidence, rests his case, if at that point, I believe, as a lawyer, trained in the law, with my experience, that he has not proven the case beyond a reasonable doubt, I have no duty, and I believe no right, to go forward and put on any case. Even if I wanted to call Victor Alvarez, which I do, to the case, I would have to stand up. I'm duty bound, if I do not believe he's proven his case, and ask the case to be thrown out by the judge. You understand that? Because he has not proven his case beyond a reasonable doubt. Now, let me ask you, Ms. Ford, if he stands up and says, I rest, that's my whole case, and he, to you, has not proven his case beyond a reasonable doubt, are you going to be looking to the defense side for them to come forward and convince you that he was not intoxicated? Or is it enough that he has in fact failed to convince you beyond a reasonable doubt that he was intoxicated?
You're saying if he hasn't shown all those things that he told us about?
Exactly. Could you at that point vote not guilty?
Is that the only chance at showing us he has?
If he stands up and says, my case is finished, I stand up and say, Judge, I'm not putting on a case. I'm not doing that because I don't think he's proven his case beyond a reasonable doubt. The case comes to you. At that point, we're already assuming that he has not proven the case to you beyond a reasonable doubt. Could you say not guilty?
I would like to hear the other side, but if I were told by the judge that I had to make a decision, then legally I would have to say not guilty.
Okay. Yeah, I think the instruction from the court will be that if you do not prove, you do not believe that the state has proven their case beyond a reasonable doubt, you must find the defendant not guilty. With that instruction, could you find him not guilty in that situation?
I would have to.
You would have to. Okay. You'd have trouble with that?
I would like to hear the other side.
Mr. Burleson, same situation. Both sides have rested and closed. You get the instruction that if you do not yourself feel beyond a reasonable doubt that the case has been proven, you have to find him not guilty. Any problem with finding him not guilty in that situation?
No, I've always heard that somebody's presumed innocent until somebody proves to me that you're guilty. I had a brother that got in trouble and I didn't think he was guilty.
Were you happy when your brother was charged with a crime that he was cloaked in that presumption of innocence?
No, not at all.
Are you happy that he was presumed innocent?
Yes, I think that he was innocent, and I think that he should have been presumed innocent until somebody showed that he was guilty.
And if they didn't show beyond a reasonable doubt that he was guilty, that presumption sticks.
That's right.
Thank you. Mr. Daly, Mr. Byrd, any problem with my not putting on any evidence whatsoever? If, in your own opinion, the state has not proven their case beyond a reasonable doubt?
When I was in the grand jury, state always had great evidence. It's hard to imagine that they bring someone to trial without having the evidence, at least some kind of evidence that would make you at least think about it.
Okay, that's a good point, because the grand jury, you were on a grand jury, and we're not going to spend a lot of time here confusing the issues, but there was no opportunity for any cross-examination, right?
Basically,
It's all the police and the prosecutor telling you what they believe the evidence shows. There was not a judge in there, correct? All right. Now, in this kind of situation, of course, I get to cross-examine their witnesses. There's a judge here to make sure that everything goes according to law. So I think that the situation is going to be much different in this situation. But my question again is, if you felt after he rested his case completely, that he had not proven his case beyond a reasonable doubt, I stood up, offered no evidence whatsoever, could you comfortably find my defendant, Victor Alvarez, not guilty?
Probably so, I think so.
Okay. Do you have some problem with that?
I would have a problem with you not wanting to do anything for your client, that's all.
I'd like to hear what he has to say.
Okay, you think that, Mr. Daly, that you could not then find him not guilty without hearing his side?
I'm not saying that, but I still think it's hard to make a decision once you hear both sides.
Okay, maybe let me break it down a little bit more for you. Let's say, in this case, that like Mr. Bailey, like Mr. Bennett said, that you have no evidence, weak evidence, certainly evidence not beyond a reasonable doubt, that Victor lost his mental or physical faculties. Okay? Weak evidence on that. But there's evidence that he went over the 1L limit on a breath test. Okay. Now, through my cross-examination of the breath test operator and the chemist involved, you don't believe in the breath test. You don't believe that that's going to do it for you. You think that that's a machine, it's a black box, it has no bearing on whether or not the person was driving while intoxicated. We have weak evidence, not beyond a reasonable doubt, on all three issues. On physical, mental faculties, and although it was over 1.0, you, after cross-examining the witness, believe that it is not shown through the black box machine that he was driving while intoxicated. And that might put it more in perspective. Then I stand up, after I've cross-examined the witness, and say, no evidence. Your Honor, in our opinion, he has not proven his case beyond a reasonable doubt. Then could we all find him not guilty?
I could.
Ms. Moore? Still want to hear his side? Believe me, we want to tell you his side too. But it would be my decision as a lawyer, after my experience and training, to stand up there and say, in our opinion, Judge, he has not done it. Let's move on to Victor's right to testify or not to testify. Kind of the same issue here. I expect that when it's my turn to stand up, I'm going to want to put Victor on the stand. He's going to want to tell his side of the story. I'm going to probably have to stand in front of him to keep him off the stand. But he has a right, I should discuss this with you, a right not to testify. And the fact that he does not testify under the Fifth Amendment of our Constitution should not and cannot be held against him in this court of law. You cannot draw inferences that he is in fact guilty and hiding something because he's not testifying. Now, we touched on this issue just recently, with us talking about arresting without any evidence. But do you all understand the Fifth Amendment? That he has a right not to testify.
I remember it because I'm old enough for Richard M. Nixon and all those trials.
Okay. Mr. Daly, do you have a problem with the Fifth Amendment in that if my client didn't testify, would you assume that he was guilty and hiding something? Could you afford him his constitutional rights? That's really
Oh yeah, I do, for sure.
Okay, but you had a little more trouble when I asked you if you were thinking that he's hiding something.
Hey, if I thought he was hiding something, I think he ought to get talk about it.
But you understand that he does not have to.
Like I said, I remember from Nixon era, he doesn't have to.
We have some reservations about this choice not to testify.
Yeah, no.
You have no reservations?
No, I understand his choice, but...
I expect the evidence is going to show in this case that the two boys in the car, Victor and his friend Pablo, were drinking while driving. Now that's drinking while driving. They had an open beer container in their possession when they were pulled over. Mr. Burleson, does that convict someone of driving while intoxicated, in your opinion, if they have an open beer in their possession?
I guess the way I understood Mr. Bennett to describe the charge, that would not convict you of driving while intoxicated.
I think that's a correct answer, too. You've had some alcohol in the past?
No, I don't drink at all.
Never had a drink?
No.
Okay. Probably not a good person to talk about this, but you might realize that if you had one sip of beer, for instance, after you opened it up, you had one sip of beer, you'd get pulled over for speeding, something like that. In your opinion, based on your experiences, do you think that that person's intoxicated? Has he lost his normal use?
I probably would be.
Because you have not ever had even a sip of alcohol. All right. But now you understand that what's not on trial here, what's not a crime, is drinking and driving. It's driving while intoxicated.
Yes, sir, I understand.
That's fine. Would you personally hold it against someone that he was drinking, had one open beer can while driving? Would you hold that against someone?
No, I think I'd be concerned about not the fact that it's alcohol, but can he drive safely with something in his hand?
It's like someone
drinking
smoking a cigarette, for instance. I see people driving with cigarettes in their hands, they're lighting a cigarette while they're driving. That same kind of issue?
Yes, sir.
About just the manual dexterity that it takes? Okay. So that would be more your concern rather than the fact that it's alcohol?
Right.
Ms. Ford, how about you on the issue of just drinking while driving? An open beer?
I don't think that means they're guilty of DWI, but I believe that is an offense now in Texas.
That's true. It's an offense for the driver to be drinking in the passenger compartment of his car. Of course, that's not what he's on trial for here.
Right.
And could you set that aside and look at the fact of whether or not he was in fact driving while intoxicated?
Yes.
Okay. And would you hold it against him that he did drink while driving?
No.
Okay, now, you understand the focus of the case we're here for today is the intoxication. Believe me, this complaint right here, we don't have any argument with any of this complaint. He was driving on a public road in Travis County, Texas on the date in question. But we have a very large problem, and the reason why we're here today is because we do not believe that he was intoxicated. But all those other blanks, all those other numbers and letters, we don't have any problem with that. The issue here is intoxication. Mr. Bird, Mr. Bailey, drinking beer while driving the vehicle?
It's perfectly legal.
Actually, for the driver to drink while driving is not actually legal.
That's true now.
Not the focus of our investigation here, you understand that? And would you hold it personally against him?
Not at all.
Mr. Daly?
I'm gonna hold the drinking personally against him.
You're gonna basically hold drinking against him, aren't you? In all fairness? Mm-hmm. Okay.
Fair state.
Thank you. Now, we touched on, Mr. Bennett did, the body of experts that allow the tonsilizer machine to come into evidence to begin with, okay? He juxtaposed that with the polygraph machine. Why polygraph is not admissible, but an tonsilizer is. Let me hasten to add that there's also a body of experts that say that the tonsilizer machine is as bad or worse than the polygraph machine. And that's what we're going to be getting into a lot here. Now, there's going to be evidence that my man did take an tonsilizer. And the results are going to be disputed. The results are going to be disputed as well as the interpretation of those results. And Mr. Brolson, I remember you had a question and a problem, and this is so important. I might be beating this dead horse here, but this is so important here when I objected in front of the judge there to stress to you that what we're here for, Mr. Brolson, is a driving while intoxicated case. And you understand that they need to show to you that this man was intoxicated. Do you understand?
Yes.
And again, for the sake of being redundant, for the sake of hammered into the ground, if you believe that he did blow over a 1-0, but that he was not intoxicated, could you find him not guilty?
I guess I'm a little confused about that. The way I heard Mr. Bennett said that I would have to find him guilty if it was any one of the three.
Okay. Well, and I objected to that because I don't think that's true.
I'll have to listen to the judge or something. I hope somebody explains that to me, because I do have a little bit of a problem, and I've tried to answer it with Mr. Bennett, that As long as I felt his capabilities were impugned, then I could find him guilty.
Sure.
But I need to feel that. I need to, either mental or physical, I don't have any problem with
Maybe the
that.
out that we're looking for here is if you believe that his faculties were not at all impaired, if he had not lost his mental or physical faculties, then do you believe that the breath test machine, that black box, was wrong?
I could believe that,
If
yes.
it had a reading over 1.0, do you think that it's just wrong? Would that be the missing key?
I could draw that conclusion if I was convinced that he could operate like a normal person and had quick reaction time and wasn't endangering anybody else, yes.
So if I can prove to you, or excuse me, if the state cannot prove to you, caught myself dead up there, the state cannot prove to you beyond a reasonable doubt that he's lost his mental or physical faculties, and through my cross-examination of the black box, you don't believe it, you'll find him not guilty. That's what I'm hearing you say.
Unless somebody tells me that the law in this state says I have to find him guilty and that I have to believe that machine,
Well, no one's going to ever tell you that.
Then-
Wilson, no one's going to ever tell you you have to believe anything because you're the judge. You're the judge of the credibility.
then
And that black box is not going to be coming into evidence. There are going to be people talking about that black box. And you're going to be able to say, I don't buy it. He did not lose his normal use of his mental or physical faculties. And that box is wrong. It's just a number on a screen. Understand that?
yes, sir. I
That's
do.
your job and your duty and your privilege to be able to throw out that piece of evidence.
I think in that situation that I'd have to be convinced that his mental or physical capacity was somehow impugned.
Ms. Ford, are you following along with that? Do you believe in that too? That if you did not believe that he lost his mental or physical faculties, could you throw away the evidence on that intoxilizer, on that machine?
Only if it was shown to me that that machine was not right.
How would you be able to juxtapose a person who was sober, or at least not intoxicated, and that he had not lost his normal use of his mental or physical faculties, and a machine, a black box with a fluorescent number that's over 1.0? How can you juxtapose
Well, there's the
that?
law and then there's common sense, as my husband always tells me.
Okay, so would common sense tell you then that the machine must be wrong?
No, common sense would tell me that the statutory requirement of .10 for intoxication may be inconsistent with what intoxication really is.
And you say,
5 minutes, Mr. McCrimmon.
thank you, Your Honor. Am I hearing you say that if any machine came in here, any black box, and they could produce an evidence that showed over 1.0, you'd feel duty bound to convict?
If that black box was shown to be doing its job correctly, yes.
And how are they going to show that to you, except for the fact that it corresponds to his mental or physical faculties of intoxication?
Well, there's the scientific evidence of what the body was doing. I mean, you could show me that he was in control for X amount of time, but that doesn't mean that his body wasn't physically intoxicated.
Okay, so you're going to believe the scientific evidence over the common sense eyewitness testimony?
I'm saying that what I believe the law is, if I believe the scientific evidence, then I have to.
And I'm not arguing with that, but do you also, on the other hand, realize you're right and duty that if you don't believe the scientific evidence, to discount it totally and to not convict? Thank you. Mr. Berg, you understand what we're talking about here? Any problems with that? If a common sense reading here of the evidence shows that the client had not lost his mental or physical faculties, yet a doxylizer machine pops up with some number over 1.0, and it doesn't jive with you, you understand that your right and duty as a juror in this case would be to discredit and throw out that scientific evidence?
I can definitely throw out the scientific evidence, but I'd have to look at everything.
Sure. But you understand the point here we're really trying to get again is, was he or was he not driving while intoxicated? Intoxicated is defined as a loss of his normal mental or physical faculties. And you're going to hear that phrase a lot.
As long as he wasn't swerving back and forth from one side of the road to the other and that kind of stuff.
Thank you. Mr. Dale, any problem with this?
No, I like to go with my gut feel.
That's all we're asking. I have couple of questions individually. Do any of you all know each other? I noticed that two of you from Maine or Texas. Do you all know each other?
Minor, but he drinks, and I don't associate with him.
I don't associate with ultra-religious people. They're kind of weird.
Okay. And Ms. Ford, your husband is an attorney, and he works with the governor of Texas?
He works for the government.
Okay. Has he ever done any prosecution in his stint?
He works for the Attorney General Enforcement Division doing federal habeas corpus.
And has he ever been a prosecutor besides through the AG's office, anything like that?
He was when we lived in Oklahoma.
Anyone related to law enforcement officers have any in your family?
Brothers, yes,
Your brothers? And I notice, Mr. Burleson, that you're a student, and I'll ask you this. The fact that this defendant and his witnesses are going to be Nicaraguan and they're here on student visas, is that going to bother you one way or another in this case? Can you totally discount that, put that out of your mind? I know we've had a lot of problems here with Nicaragua in the last couple of days. If I could have planned this trial, I should have put it a couple of weeks ago. But are you going to hold Victor accountable for what's going on in Nicaragua right now?
No, I don't think, I think I can push that aside from the driving while intoxicated. I don't like what's happening down there, but...
That's understandable too. But you're not going to hold Victor responsible for what happens in the embassies, right?
No.
Anybody else?
It's like a refugee. I feel sorry for him.
Okay, I think I'm going to be changing my plea here.
Thank you, gentlemen. Okay, Al, would you tell the class what you were trying to do on Voir and your reaction to any of the panel members?
Y'all have advocacy skills classes, that kind of thing, and learn about Voir and where you're supposed to be doing all that kind of stuff. I guess you're going to Baylor. Anyway, what you want to do, let's talk Voir pass, right? What you want to do in Voir is prejudice the jury to your side of the case. You want to find someone in a DWI trial, you want to find someone and say, yeah, I did really run over by a drunk driver. Oh, really? Tell us about that. And obviously from the defense standpoint, you say, Your Honor, this person can talk about this in front of the court, in front of the judge. Basically, that's your first and only opportunity to prejudice them, to bias them, to get them as much on your side of the case as you possibly can, and keep them away from the defense side. For example, the very last one, the one gentleman said concerning whether your guy was like Robert, you got to kind of feel sorry for him. You don't want any of these people feeling sorry for the defendant. In fact, if you have more time in voir dire, you want to get out those kinds of feelings of sympathy and make sure they can disavow them. For example, that's why you always want to find out who all has been driving while intoxicated. Let's face it, I mean, unless there's some people in here that don't drink, we've probably all been driving while intoxicated. And, well, there's one person that never has. But I mean, that's something that the state, that's something the state obviously has a problem with, because there are a lot of people sitting on juries thinking, well, you know, I've done that myself. You know, there's probably been some times when I shouldn't have been driving. Here, I'm going to convict this guy for something I myself have done. You need them to get them to put away those kinds of feelings, and I think primarily, I imagine is what the defense tries to do. You want to get them prejudiced against the state and feel sorry for my poor guy going against the state of Texas with all its power and might and all that. And that's something, if you had more time in voir dire, you'd want to say, look, can you disavow those feelings of sympathy? Not hold it against the state, it is the state against this one poor little man, because after all, we represent you, the taxpayers, and that kind of thing. But primarily, that's what you want to do in voir dire. That's your first and only chance to win them over to your side. Now, in your opening statement, you're going to tell them about the case, but you're not going to have a chance to interact with them to find out what their feelings and prejudices are. And by the same token, there's always someone on the panel that says, well, I saw on 60 Minutes that intoxicants are just way off all the time. And the defense counsel are obviously going to dwell on that to, as we call, poison the mind of everyone else on the panel, so that the 6 you get are going to be thinking, well, that one guy saw on 60 Minutes that intoxicants is never right. Whereas I'm going to try to find someone and say, well, I believe in that intoxilizer, and my kid brother got run over by a drunk driver, and I think it's just a heinous offense and get everyone thinking about, yeah, this is a serious thing. We need to teach this guy a lesson and show everyone how important it is. I think primarily that's the general gist of what our...
Any of y'all have any questions?
Oh, yeah.
Got one?
Yes,
My
sir.
question, who would you have tried to, because you either want to strike for cause, who would you just use your one strike against?
For cause, I'm sure you would go for the religious person. And I would say, well, Mr. So-and-so, could you be fair and could you be impartial and not decide this case before you heard the facts? Because no one's ever going to say, well, no, I couldn't be fair, I couldn't be impartial. At which point I turn and say, well, Your Honor, he's qualified. He says he can be fair, he can be impartial. And at which point the judge is never going to buy that.
We do with the people that obviously try to get off the jury, like, I mean, they've got other things they want to do.
Oh, yeah, and there are a lot of people who will say, could you be fair and could you be impartial? Well, I will try to be.
But what about no?
And there are people, I had one panel a while back that they said, yeah, my brother or some relative was involved in a DWI accident, and I would have a hard time putting that out of my mind. Well, could you be fair, could you be impartial? I don't know what to try. Oh, Your Honor, he's qualified. No, that's not qualified.
What's important is that you don't blow it by trying to establish your cause challenge in front of the rest of the jury panel. Because if you see somebody, especially somebody trying to get off a panel, they're going to say some outrageous things. Make sure you get them up in front of the bench out of the presence of the other jurors so they can start, acting crazy up there. Because if they start saying, well, I think DWI it's murder, then it's great. But, so you're going to want to make sure that if you see this thing getting out of hand, pull them up real quick.
Of course, like I say, we always try to say, well, now, who here has been involved in a DWI accident and all that? And I had one defense attorney say, well, Your Honor, and he didn't practice a lot in our county courts here, said, Your Honor, anyone who's had personal involvements with driving while intoxicated, I'd like to proceed with those questions after the whole void hour is done individually in front, for that very reason, not to prejudice, not to bias the entire panel.
Your body parts are spread all over the...
Why did you mention that you've driven
As soon as I said that,
while having...
Yeah, well, see, you're going to get struck anyway by him.
Well, I know that, but I'm not talking about from a role-playing part. I mean, I thought that was kind of odd that you admitted driving while, drinking and driving while under the influence.
To be perfectly honest with you, I've never done that in front of a real panel, and I've thought about it a lot of times because it is so important to get that out in this board. For sure, our role, I take it. But that is really something. I mean, when you look at 6 people on a jury, you look at 18 people, you know that a bunch of those people have been driving while intoxicated. And yes, I've been on the road, and I don't know if I like to really say that to a real panel, but yeah, I've been on the road, and I'm sure a bunch of you all have, except for this person. Let's be honest here. Let's face it, everyone drinks. And there have been times where everyone says, well, I've got to go 2 blocks down the road. And I've had a lot to drink, and it's probably the best time, but I'm not going to swerve out of my lane. I can still say my ABCs, and I can probably pass field sobriety. But in your heart, you don't want to have the opportunity to blow into intoxicator. I mean,
But don't you think immediately that it sends the jury's sympathies to the other side when you just admitted to the entire panel that you've done it, and the only difference is he did it and got caught?
yeah.
I like when you said it.
That's probably why I'll never say it. But the same token, like this guy here, who's obviously an alcoholic.
I want to argue with this guy anyway.
I would try to get you stricken for call or use a drinker on you, but let's face it, you drink and drive all the time, and you don't have any problem with it. I'm going, look, I've done it. Is there anyone else here who's done it? Ms. Ford kind of nod her head. I mean, you seem to nod your head, but I got the impression that you thought long and hard about it, and just from the expression on your face, that maybe you realize that, yeah, I've done it, it's wrong, I shouldn't have it. I think it's important to get people to realize that, yeah, this is something I've done, but I have to not let that influence my judgment as to this person. Like I said, I've never really said that in front of a real panel.
It might have gone just over the line there. But I know in Travis County that the prosecutors are real nice, and they go all out by saying all these things about how the defendant, they have good counsel, and they're not chicken shit at all. And I think that's good to get that jury thinking, well, this is a pretty good guy. He's not like a real hard-ass prosecutor. That might have gone just a touch over the line.
And that's real important in closing argument, which is next to void iron closing, the best parts of the trial. In closing argument, it's a little bit related, I always say, I don't know this man, I've never met him, and sitting there, he looks like a perfectly fine guy, and I'm not making any moral judgments about him whatsoever. Because I don't want the jury thinking, well, I don't want him to think that I think he's a bad guy. And I'm saying, I'm not saying he's a bad guy, I'm not saying he's a bad person, I'm not making any moral judgments, that's not what we're here to do. We're here to decide the facts, and the facts are A, B, and C. And we've proven A, B, and C, and we need to convict this maggot. No, I'm kidding. Anything else? Any questions?
When you were saying you pulled the prospective juror up before the judge before he said DWI people were murderers, would you actually pull them up to the bench and get rid of them then, or would you just stop asking questions?
Depends on the judge. A lot of judges don't like to break it up and have them come up to the bench one at a time. They like to wait until the whole thing's over and then bring them up in a row. I always like to get them up instantaneously so that if they get excused for cause, and they obviously are going to say some weird things to try to get off the panel, they're gone. And they don't have to sit there and they don't have to keep poisoning the jury. But more and more, especially in felonies, they just bring them all up at the end. And so then you just got to, what you do is like, on the end here, I would say, would anyone hold it against him that he's driving and drinking? Except for you, so you don't give him another chance to say, well, I mean, anyone that drink and drive, that's it. He's a murderer, and he's just, just cut him off and say, except for you, like that.
Can you shut them up? I mean, when they start to talk, can you say we've heard enough? You answer the question.
Do your best. You can say, we understand your position. Told us 3 or 4 times now. Thank you.
How come you didn't ask any questions about our backgrounds? Like,
I ran out of time.
he volunteered his religious background, but if he hadn't, you would have never done that.
Well, that helped a lot right there, is that I had written down here that Burleson was Baptist, does not drink. You had mad connections, and your prosecutor husband, Bird, drinks a lot, DWI, and you thought it was a sin to drink. So when you get that off the bat, you really kind of know where they're coming from, I think. Of course, half an hour also is pretty short, but...
How long do y'all get in district courts, or do they give you any limitations?
Not really, 45 minutes, 45 an hour.
Mark, could you explain what you were trying to do, other than to kill 30 minutes?
What I had a real trouble with, and what I was beating the dead horse with over here, was this 1-0 is going to be guilty, period. And that was just killer. And when I tried to object, he overruled my objection. So I had to go back out there, even if it is killing a horse, I'm going to have to say, look, come on. The guy has not lost it, but he has over 1-0. You're not going to really find this guy guilty, are you? Because we know it's a 1-2. And that's going to come out. You can cross-examine all you want, that 1-2 is going to come in. The breath test slipped, and it looked good. And, did I win here?
Yeah.
Just out of curiosity, what's the law?
I don't know if there's law on that. I think that you kind of had that problem right there. I think if it's over 1-0, it's per se intoxication, but you have to believe that the 1-0 means blood alcohol is not there.
I think that the objection was a good one. I think your objection was a bad one, that he stated the law properly, that if they believe that it was a 1-0 and they believe the machine was working properly, then that is intoxicated. Right. It doesn't make any difference whether they lost the normal use of their physical and mental faculties or not. But I think your counter to it is, well, you wouldn't think all that stuff was right if the guy was sober, would you?
Right. At the expense of having to really beat that down, I had to get at least you to say the only way out of juxtaposing a 1-2 with normal use is that it's a black box.
The real answer is that it's per se intoxication.
If you believe the predicate.
If I believe the box. I mean, if I believe that it measured the percentage of alcohol in the blood, regardless of how it impacts that guy, he's got an immunity built up or a tolerance that doesn't affect him at all, I've got to say he's guilty.
Well, that being the case, you'd think no one would ever lose a 1-1 or 1-2.
That's true.
Or 1-9. Or 1-9, but routinely juries come back to, well, I just don't believe that machine.
Yeah. That's the out. That's the out.
Yeah.
It's real easy to cause the jury.
It seems like, that's, Alan, that's where you'd really come across strong, either in voir dire or closing, that, hey, you've got to have some reason to believe that this machine is wrong, and you've heard the expert, if you think that machine was right and it's .11, you've got to find him guilty. I mean,
Yeah, although maybe I misstated it, I never meant to say you had to find him guilty if you believe the machine, if you believe that, because that, I believe, is an incorrect statement. The jury can always find the guy innocent, regardless of the evidence. What I meant to say was you could find him guilty based solely upon the results of that machine if you believe that he was over a .10 and you believe the machine was operating correctly.
it's a correct statement then to say that it's a violation of the law to have a blood alcohol content of greater than .1.
That's right.
Yeah, it used to be, I think when I was in law school at Chambers, it used to be if you blew a 1.0 or above, you were presumed to be intoxicated. And then later the legislature said, no, you are no longer presumed to be intoxicated if you blow a 1 or above. .1 or above is now a definition of intoxication. And everyone said, well, wait a second, that's an irrebuttable presumption. He's guilty as a matter of law, and that's unconstitutional. And the criminal court of appeals said, no, that's not presumption, that's just a definition. And the juries can and routinely do disbelieve the machine itself.
Another thing on my side is you have to give up a lot, when you have bad facts. And drinking and driving, you have to give that up. That's going to come out. And then I was going to get to the theft conviction. If you a DWI like this, you probably have to call your guy, and you don't want it coming out. You might wait and get it out, clean it up on your direct. Like kind of your third question might be, now you stole that cat food for that runaway cat that was on your front porch, and you kind of like, and instead of getting a lawyer and getting that thing probated, you went ahead and pled guilty, and now you have a theft conviction. Because he's going to have that. You have to front that. Because if you don't clean that up either on voir dire or early on in your direct, then he's just going to say, look at your record here, you have a theft conviction, right? And not giving any out whatsoever. And like drinking and driving, you got to front that. You got to find out how that affects them. And I don't think you should ever say what the breath test came out as, like if it's 1.2 or 1.9 or something like that, because you might just kind of play with that like over the limit, because you're not sure it's going to come in. There's a lot of ways that it doesn't come in.
And I was always told not to mention that in the voir dire opening statement, and then you're asking for a mistrial to do so. Now, other jurisdictions, from my understanding, say, there's no problem with that, we talk about it all the time. But,
State? The state?
Yeah, it was for the state to mention that.
Have breath test at all?
Yeah, not to mention, yes, and the evidence is going to show if you rule 1-2. I've always understood that to be just
I
asking
think
for
you have a mistrial on your hands if it doesn't come in.
I don't know. It seems to me they can talk about what they expect the evidence to show if they do it in good faith, and then just instruct the jury to disregard it.
I think if the breath test was thrown out and voir dire, you found out that he had a 1.2, then
Of course, you're going to be the state over there, going, where is that breath test they talked about?
another thing on a more practical level is that I'm sure you've learned by now from your instructors that good preparation wins cases and makes for good voir dire. I put all 20 minutes into mine beforehand, and that's really more practical about what, you have this jury document of 20 cases, especially if you're in the state, you really have to be able to rely on a pretty routine, pretty pat voir dire. Because you don't know if it's the first case is going or the seventh case is going. And if it's a DWI, you got to be ready to go and just fill in the blanks with names and UTPD versus APD. Because you really don't have that time to really go out there and investigate every voir dire and every case, and especially him. But more and more it's true on this end. It's great to have the luxury of having 2 cases pending. You can really work them up and you really can get your voir dire together. But you should make notes along the way when you pick up good things and put them in your trial notebook for your next voir dire. When you're number 7 on the docket and you went out partying with your friend from out of town, and you thought, well, I'm number 7 on the docket, it's not going to go. All of a sudden 6 cases plead or get dismissed and you're up there in front of the jury and you're going, shit. That's when you got to open up that trial notebook and you have a pretty good voir dire to go with.
That is important. I don't know if anyone's ever told you all, but they always told us if you want to be a good trial attorney, and some people don't ever want to get near the courtroom, but if you do, a good way to get ready for that is read the works of trial attorneys. Read all those books by F. Lee Bailey and Clarence Darrow and all that. It's inspirational, if nothing else. And just steal anything and everything from everyone.
I stole Allison's little bar here. He does a lot better than me, but that's, I think, really good on beyond a reasonable doubt. When you throw in that clear and convincing evidence is way up there on the bar. then you only have about this much evidence left to talk about beyond a reasonable doubt.
I don't even do that anymore. That was last year's court hour. I'm waiting on
Is
that.
that
Allison's new technique, he lets the defendant do the voir dire.
We just communicate without talking.
Yeah, you can't steal someone else's stuff directly, but I mean,
not in their own class.
yeah. You all got your own personality and your own styles, but pay attention to what other people do and read what other people do, and every chance you get, try to see someone else in action in the courtroom.
Yeah, watching trials, watching
Yeah,
lawyers,
the next best thing to trying a case is watching a case being tried.
watching people before you try them too.
I'll try to, but, I don't steal stuff directly, but obviously there are going to be a lot of things you're going to say, yeah, that kind of fits my style, my personality, I can use that, and you can pick up a lot of good stuff that way. And my closing argument, I mean, changed the names and the dates, and all of my closing arguments are the same pretty much, at least for DWI trials.
Anybody have any more questions? Gentlemen, thank you very much.
Thank you.
See you next Thursday.
Oh, yeah.